Hello everyone. Today I will be discussing the Republic Act number 10587, also known as Environmental Planning Act of 2013. What is Environmental Planning Act all about? It is an act regulating the practice of environmental planning, repealing for the purpose Presidential Decree number 1308 entitled Law Regulating the Environmental Planning Profession in the Philippines, and for other purposes. After review and approval of the PRC, the Professional Regulatory Board of Environmental Planning hereby adopts this resolution to effectively implement, administer, and enforce the provision of RA 10587 or Environmental Planning Act of 2013. Under RA 10587, there are 7 articles. Article 1, General Provisions. Article 2, Professional Regulatory Board of Environmental Planning. Article 3, Examination and Registration. Article 4, Practice of Environmental Planning. Article 5, Enforcement of this Act and Penal Provisions. Article 6, Transitory Provisions. And Article 7, Final Provisions. Article 1, General Provisions. Section 1 titled, This Act shall be known as the Environmental Planning Act of 2013. Section 2, Declaration of Policy. The state recognizes the importance of environmental planning in nation building and development. Hence, it shall develop and nurture competent, virtuous, productive, and well-rounded professional environmental planners whose standards of practice and service shall be excellent, world-class, and globally competitive through honest, effective, relevant, and credible licensure examinations and through regulatory programs, measures, and activities that foster their professional growth, social responsibility, and development. Section 3. Coverage of this Act. This Act shall cover the following aspects of the practice of the profession: examination, registration, and licensure of environmental planners, the supervision, control, and regulation of the practice of environmental planning, the development, upgrading, and updating of the curriculum of the environmental planning profession, and development and improvement of the professional competence and practice of environmental planners through, among others, continuing professional education and development. Section 4. Definition of terms. Environmental planning, also known as urban and regional planning, city planning, town and country planning, and/or human settlements planning, refers to the multidisciplinary art and science of analyzing, specifying, clarifying, harmonizing, managing, and regulating the use and development of land and water resources in relation to their environs for the development of sustainable communities and ecosystems. Environmental planner refers to a person who is registered and licensed to practice environmental planning and who holds a valid certificate of registration and a valid professional identification card from the Board of Environmental Planning and the Professional Regulation Commission. Accredited Professional Organization, or APO, refers to the duly integrated and accredited professional organization of environmental planners, of which there shall be only one as prescribed by the Republic Act number 8981 and the Comprehensive Professional Code and in Section 32 of this Act. Section 5. Scope of Practice. The practice of environmental planning within the meaning and intent of this Act shall embrace the following. A. Providing professional services in the form of technical consultation, rendering or technical advice, plan preparation, capacity building, and monitoring and evaluation of implementation involving the following. 1. National, regional, or local development and/or physical framework and comprehensive land use plans. 2. Zoning and related ordinances, codes, and other legal issuances for the development and management, preservation, conservation, rehabilitation, regulation, and control of the environment, including all land, water, air, and natural resources. Planning and development of a barangay, municipality, city, province, region, or any portion of combination thereof, and development of a site for a particular need or special purpose, such as economic or ecological zones, tourism, development zones, and housing and other estate development projects, including the creation of any other spatial arrangement of buildings, utilities, transport, and communication. B. In relation to any of the activities enumerated, preparing the following studies. 1. Pre-feasibility, feasibility and other related concerns. 2. Environmental assessments. And 3. Institutional, administrative, or legal systems. C. Curriculum and syllabi development and licensure examinations for environmental planners and teaching in academic institution and conducting review courses in environmental planning. D. Serving as expert witness, resource person, lecturer, juror, or arbitrator in hearings, competitions, exhibitions, and other public fora, conduct of hearings, competitions, exhibits, and other public fora. E. Ensuring compliance with environmental laws, including in the acquisition of regulatory permits. The Professional Regulatory Board, subject to approval of the Professional Regulation Commission, may add to or exclude from this section any activity or act of professional practice, or revise it as the need arises to conform to changes and new developments brought about by the latest trends in environmental planning. And F. Perform other acts or conduct other activities that may be determined by the board, subject to approval by the Professional Regulation Commission in light of the trend of the practice of the profession. Article 2. Professional Regulatory Board of Environmental Planning. Section 6. Professional Regulatory Board of Environmental Planning. There is hereby created a Professional Regulatory Board of Environmental Planning, hereinafter referred to as the Board, which shall be composed of a chairperson and 2 members under the administrative control and supervision of the Professional Regulation Commission, hereinafter referred to as the Commission. Section 7. Term of Office. The chairperson and the members of the board shall hold office for a term of 3 years from the date of their appointment, or until their successors shall have qualified and been appointed. Section 8. Qualifications of board members. Each member of the board shall, at the time of his or her appointment, possess the following qualifications: a citizen and resident of the Philippines, of good moral character and of sound mind, a holder of a master's degree in environmental planning or its equivalent, a registered and licensed environmental planner with a valid certificate of registration, and a professional identification card with at least 7 years of practice in environmental planning prior to his or her appointment. Not a member of the faculty of any school, college, or university where a regular academic course or the review course in environmental planning is offered, nor a member of a staff of reviewers in a review school or center, and does not have any direct or indirect pecuniary interest in such an institution. A member in good standing but an officer or trustee thereof of the APO, and not convicted by a court of competent jurisdiction of an offense involving moral turpitude. Powers, duties, and responsibilities of the Board. The Board shall have the following specific powers, duties, and responsibilities: prescribe and adopt the rules and regulations necessary to carry out the provisions of this Act, supervise the registration, licensure, and practice of environmental planning in the Philippines, administer oaths in connection with the implementation of this Act, issued, suspend, revoke, or reinstate certificate of registration for the practice of environmental planning, adopt an official seal of the Board, prepare the contents of licensure examination, score and rate the examination papers, and submit the results thereof to the Commission. Adopt and promulgate a Code of Ethics and a Code of Technical Standards issued by the APO. Assist the Commission on Higher Education to ensure that all instruction and offering of environmental planning comply with the policies, standards, and requirements of the course prescribed by the CHED or other authorized government offices in the areas, among others, of curriculum, faculty, library, and facilities. Adopt measures necessary for the enhancement of the profession. Investigate officially reported violations of this Act and its rules and regulations, Code of Ethics, Code of Technical Standards, policies and measures, and for this purpose issue subpoena and subpoena ducis tecum to secure the appearance of witnesses and submission of the documents and other evidences necessary in connection with the performance of its functions. Seek the assistance of the Commission in the conduct of hearing or investigation of administrative cases filed before the Board. Promulgate decisions on such administrative cases. Discharge such other powers and duties that may affect professional, ethical, and technological standards of the environmental planning profession in the Philippines, and perform such other functions and responsibilities in accordance with the provisions of Republic Act No. 8981, otherwise known as the Professional Regulation Commission or PRC Modernization Act of 2000. Section 10. Compensation of the Board. The chairperson and members of the Board shall receive compensation and allowances comparable to the compensation and allowances received by the chairperson and members of other existing professional regulatory boards under the Commission as provided by the General Appropriations Act. Section 11. Administrative supervision of the Board, custodian of its records, secretariat, and support services. The Board shall be under the administrative supervision of the Commission. All records of the Board, including applications for examinations and administrative and other investigative hearings conducted by the Board, shall be under the custody of the Commission. The Commission shall designate the Secretary of the Board and shall provide the Secretariat and other support services to implement and provide provisions of this Act. Article
Section
3.
15.
Examination required, unless provided
registration.
otherwise under this Act.
Under
All
Section
applicants
14,
for registration
required.
for the practice of
Upon
environmental
the effectivity
planning
of this
shall be
Act,
required
no
to
person
pass
shall
the
practice
professional
or offer to
licensure
practice
examination
environmental
as herein
planning in the
provided,
Philippines,
subject
without
to the
having
payment of
obtained
fees from the Board
prescribed by the
and the
Commission,
Commission. A certificate of
examinations for the
registration
practice of
and a professional
environmental planning in
identification
the
card
Philippines
shall be
or
given
a
by the Board at
temporary
least
or a
once
special
every year
permit.
in such places and dates as the Commission may designate in accordance with the provisions of Republic Act 8981. Section 16. Rating in the licensure examination. To pass the licensure examination, each person must obtain a weighted average of not less than 70 per centum and a rating of not less than 50 per centum in any examination subjects. Section 17. Subjects of examination. The licensure examination for environmental planners shall include but shall not be limited to the following: history, concepts, theories, and principles of environmental planning, environmental planning process, methods or techniques, and strategies, environmental plan implementation, legal aspects, and administration. Section 18. Qualification for taking the examination. Any person applying to take the licensure examination as herein provided shall establish to the satisfaction of the Board and that he or she has the following qualifications: a citizen of the Philippines or a foreign citizen whose country or state has a policy of reciprocity in the practice of the profession, a holder of any of the following degrees from schools, colleges, or universities duly recognized and accredited by CHED. 1. A graduate in environmental planning, urban or city and regional planning, or town and country planning or its equivalent. 2. A postgraduate diploma in environmental planning, city and regional planning or its equivalent, and with at least 1 year of on-the-job training as required herein. 3. A bachelor degree in environmental planning, city planning or urban and regional planning, or town and country planning, or its equivalent, and with the 2 years of on-the-job training as required herein. 4. A master's or doctorate degree in either architecture, engineering, ecology, economics, geography, geology, public administration, business administration, sociology, social science, law, environmental science, environmental management, development management, natural resources planning and development, and related disciplines acceptable to the board, and with 3 years of on-the-job training as required herein, provided that a person falling under this paragraph shall be allowed to take the licensure examination only within the next 5 years from the effectivity of this act. 5. A bachelor's degree in architecture, engineering, economics, public administration, law, social work, and community development or sociology, and other related disciplines acceptable of the board, and with 5 years of the on-the-job training as required herein, provided that the person falling under this paragraph shall be allowed to take the licensure examination only within the next 5 years from the effectivity of this act. 6. Incumbent holders of planning positions in the national, regional, or local government offices or agencies including government-owned and controlled corporations that have been engaged in development planning functions acceptable to the board, provided that they are holders of professional civil service eligibility and they have undergone an at least 80 hours of in-service training or distance learning in developmental planning from a government agency, school, or institution recognized by the proper authorities, provided further that a person falling under this paragraph may be allowed to take the licensure examination only within the next 5 years after the effectivity of this act. Of good moral character, not convicted of an offense involving moral turpitude by a court or competent jurisdiction. Section 19. Issuance of Certificate of Registration and Professional Identification Card. A certificate of registration shall be issued to those who are registered after payment of fees prescribed by the Commission. A professional identification card bearing the registration number and its validity and expiry dates duly signed by the chairperson of the Commission shall likewise be issued to every registrant who has paid the prescribed fees and has submitted a certificate of membership in good standing from APO. Refusal to register. The board shall not register any successful applicant for registration with or without licensure examination who has been convicted of an offense involving moral turpitude by a court of competent jurisdiction, found guilty of immoral or dishonorable conduct by the board, adjudged guilty for violation of the general instructions to examinees by the board, and declared of unsound mind by a court of competent jurisdiction. Section 21. Revocation or suspension of the certificate registration and cancellation of temporary or special permit. The board shall have the power upon notice and hearing to revoke or suspend the certificate of registration of a registered and licensed environmental planner or to cancel a temporary or special permit granted to a foreign environmental planner for the same grounds enumerated in Section 20 of this Act, except paragraph hereof and any of the following grounds. Violation of any provision of this Act, implementing rules and regulations, code of ethics, code of technical standards for the practice of environmental planning, and of policies and regulatory measures of the board and or the commission, and code of good governance. Perpetration or use of fraud in obtaining his or her certification of registration, professional identification card, temporary or special permit. Gross incompetence, negligence, or ignorance in the conduct of the professional result to death, injury of person and or damage to property. Unjustified refusal to join or to remain a member in good standing of the APO. Unjustified or unexplained neglect or failure to pay the annual registration fees for 5 consecutive years. unjustified or unexplained non-renewal of the professional identification card after the lapse of 5 consecutive years, aiding or abetting the illegal practice of an unregistered and unlicensed environmental planner by, among others, allowing him or her to use his or her certificate of registration and/or professional identification card or his or her temporary or special permit, illegally practicing the profession during his or her suspension from the practice thereof, and addiction to a drug or alcohol abuse, impairing his or her ability to practice his or her profession or declared with an unsound mind by a court of competent jurisdiction. Section 22. Filing of charges. Any person, firm, or association may file charges against any registrant in accordance with the provision of Section 21, or the Board may investigate violations of any of the above-mentioned provisions. An affidavit complaint shall be filed together with affidavits of witnesses and other documentary evidence with the Board through the Commission's Legal and Investigation Office. Section 23. Reissuance of the revoked certificate of registration. Replacement of lost or damaged certificate of registration, professional identification card, or temporary or special permit. The Board may, upon petition, reinstate or reissue a revoked certificate of registration after 2 years from the effectivity of the revocation, which is the date of surrender of the said certificate and/or the professional identification card to the Board and/or the Commission. The Board may not require the holder thereof to take another licensure examination. The petitioner shall prove that the Board that he or she has valid reasons to resume the practice of his or her profession. For the grant of his or her petition, the Board shall issue a Board resolution subject to approval by the Commission. Article 4. Practice of Environmental Planning. Section 24. Vested Rights. Licensed environmental planners registered when this law is passed. All environmental planners who are already duly registered with the Board under Presidential Decree Number 1308 and are holders of valid professional identification card issued by the Commission and who are in good standing with the APO of environmental planners at the effectivity of this Act shall be deemed automatically registered under this Act. Section 25. Consulting firms, partnerships, corporations, associations, and foundations engage in environmental planning practice. A consulting firm, partnership, corporation, association, or foundation may engage in the practice of environmental planning in the Philippines, provided that it complies with the requirements. Section 26. Use of seal. All registered and licensed environmental planners shall obtain a seal of such design as the Board shall authorize and direct. Section 27. Continuing professional education. The Board, in consultation with the Academe and APO, shall prescribe guidelines in the implementation of its continuing professional education programs, subject to the approval of the Commission. Section 28. Foreign reciprocity. A foreign citizen may be allowed to take the licensure examination and may be given a certificate of registration and professional identification card if he or she can prove that the country or state of which she or he is a subject or citizen allows a Filipino environmental planner to practice his or her profession within its territorial limits on the same basis as the subjects or citizens of such foreign state or country. Section 29. Special or temporary permits for foreign environmental planners. The practice of foreign environmental planners in the Philippines shall be limited to the natural persons only, and shall be governed by the provisions of Republic Act No. 8981, otherwise known as the Professional Regulation Commission PRC Modernization Act of 2000. Section 30. Information required on plans. The environmental planner shall be required to indicate his or her certificate of registration and/or PRC identification card, APO certificate of membership, and professional tax receipt numbers. date and place of issuance and expiry on all plans and other documents signed by him or her. Section 31. Unlawful practices under this Act. It shall be unlawful for any person or group of persons to offer or render planning services as defined in Section 4 or within the scope of Section 5 of this Act when he or she is not a registered and licensed environmental planner. Cause, induce, encourage, or coerce with preparation of or implementation any plan that is not signed by a registered and licensed environmental planner when such plan is so required by this Act to be signed by a registered and licensed environmental planner. Amend, revise, duplicate, or make copies of plans, designs, programs, and other documents prepared, signed, and sealed by a registered and licensed environmental planner without his or her explicit and written consent, and sign his or her name, affix his or her seal, or use any other method of signature on plans, specifications on other documents not actually prepared by him or her. Section 32. Accredited Professional Organization (APO) of Environmental Planners. All registered and licensed environmental planners shall organize themselves into one national organization that is duly registered by the Security and Exchange Commission. Article 5. Enforcement of this Act and Penal Provisions. Section 33. Enforcement by the government officials and officers of the law. It shall be the duty of all government officials and duly constituted law officers of the national, provincial, city, or municipal government to assist the Board and the Commission in enforcing the provisions of this Act and to cause the prosecution of any person violating the same. Section 34. Positions in government with environmental planning functions. The Civil Service Commission shall create position and set qualification standards for environmental planners at various levels in government service, including government-owned and controlled corporations and other entities. After the lapse of 5 years from the effectivity of this Act, only registered and licensed environmental planners shall be appointed to the position of heads and assistant heads of the group, departments, divisions, in government offices, agencies, bureaus, or instrumentalities thereof, including government-owned and controlled corporations, provinces, cities, and municipalities, and such other positions which require the knowledge, skills, and competence and qualification of registered and licensed environmental planners. Appointments made thereafter in violation hereof shall be considered null and void. Section 35. Civil Liability of Environmental Planners. The environmental planner in charge of the preparation of an environmental plan and related documents, as well as other members of the planning team involved in the preparation thereof, may be held civilly liable in case of serious, large-scale, or wholesale damage, failure, or destruction of any project subject of or covered by an environmental plan that result in significant adverse impact on affected stakeholders or the concerned ecosystem within period of 10 years from the time of implementation of such plan. These are in cases where it is determined by the court or of competent jurisdiction that such damage, failure, or destruction was foreseeable and could have been anticipated, and are directly caused by gross negligence on the part of such environmental planner and or the environmental planning team member or members, or to highly deficient or inappropriate environmental planning methods, strategies, tools, or techniques at variance with generally accepted environmental planning principles, methods, and standards. The government or any affected stakeholder may bring an action to enforce such liability within 5 years from the time the damage or destruction occurs. Section 36. Penal Provisions. Any person committing any of the unlawful practices under Section 31 hereof and or any of the following acts shall upon conviction be sentenced by imprisonment of not less than 6 months or nor more than 5 years, or a fine of not less than 100,000 pesos or not more than 500,000 pesos, or both, at the discretion of the court. Engaging in the practice of environmental planning in the Philippines without having been registered and licensed or without having conformed to the provisions of this act. Presenting or attempting to use or as his or her own the certificate of registration and or professional identification card of another registered and licensed environmental planner or a holder of a temporary or special permit. Giving any false, forged, or tampered evidence of any kind to the board, or impersonating any registered and licensed environmental planner or a natural person who is holder of temporary or special permit. Using a revoked or suspended certificate of registration or an expired or unrenewed professional identification card or temporary special permit. Using in connection with his or her name or otherwise assuming, using or advertising any title of description tending to convey the impression that he or she is a registered and licensed environmental planner without holding a valid certificate of registration and professional identification card or a valid temporary special permit. Implementing or causing the implementation of any plan not prepared and signed by a registered and licensed environmental planner. Violating any of the provisions of this act and the rules and regulations thereof. Any Filipino employer who hires foreign practitioners without obtaining a special permit for the latter shall also be held liable under this act, in case the offender is a corporation, partnership, association, foundation, or juridical person. The penalty of imprisonment shall be imposed on the registered and licensed environmental planner in charge, jointly and solidarily, with the responsible professionals as well as the controlling officer or officers thereof responsible for permitting or causing the violation. Article 6. Transitory Provisions. Section 37. Within a period of 3 years from the effectivity of this Act, local government units may continue to issue appointments to persons who are not registered and licensed environmental planners for the position of national or local planning and development coordinators, or chief of local planning and development offices, only a temporary status or acting capacity. The incumbent chairperson and members of the board shall, in an interim capacity, continue to carry out their functions under the provisions of this Act, without need for new appointments as chairperson and members thereof until the first board, created under this Act, shall have been constituted or organized pursuant thereto. Article 7. Final Provisions. Section 38. Appropriations. The chairperson of the Commission shall immediately include in its programs the implementation of this Act, the funding of which shall be included in the Annual General Appropriations Act and thereafter. Section 39. Act not affecting other professions. This Act shall not affect or prevent the practice of any other legally recognized profession. Section 40. Implementing Rules and Regulations. The Board, subject to approval of the Commission, shall prescribe, promulgate, and issue the implementing rules and regulations of this Act after consultation with the APO, other agencies, and concerned private organizations with 120 days from the constitution of the Board. Section 41. Separability Clause. If any part or section of this Act shall be declared unconstitutional, such declaration shall not invalidate the other provisions hereof. Section 42. Repealing Clause. Presidential Decree Number 1308 is hereby repealed. All other laws, orders, rules, and regulations, or resolutions or parts thereof inconsistent with the provisions of this Act are hereby repealed or amended accordingly. Section 43. Effectivity. This Act shall take effect 15 days following its publication in the Official Gazette or in 2 newspapers of general circulation in the Philippines. This act, which is consolidated of Senate Bill number 3138 and House Bill 4692, was finally passed by the Senate and the House of Representatives on February 4, 2013 and February 5, 2013 respectively. And that ends my report. Thank you.